I'm Bartosz Jóźwiak. I'm an attorney at law, and I run and co-founded Raczyński and Jóźwiak Attorneys at Law in Poznań.
And my name is Bartosz Fert, the second Bartek here.
Right. So we want to tell you... okay. Okay, there we go. Okay. Well, we will tell you about... we're both in intellectual property rights, legal issues. We have a slightly different approach to it. I'm running a firm that goes into starting from litigation to negotiations of contracts to managing IP portfolios of our clients and consult them along the way, while Bartek is more into, well, maybe you will tell it.
Okay, so as I said, my name is Bartosz Fert. I'm running a little company that is responsible for clearance and registrability searches of intellectual property law, and I'm the one responsible for prosecution of those rights. So as Bartek is responsible for the big picture, I'm the one, the intermediary between the patent office and you. What we're going to talk about, that's a hostile takeover of intellectual property rights, and that's a true story.
Yeah, the aim of this presentation is not to scare anybody, because lawyers tend to scare people off, right? We don't want to scare you. We want to simply tell you the story of a company that was attacked. They need to defend themselves against an attack on their IP assets, intellectual property assets. What you can think of as a startup, you know, startups tend to be focused on development, on creation, right? They just execute the idea. They just want to introduce something to the market, to the world. You are not necessarily focused on trademarks, patents, copyright issues, unfair competition issues. That's something that goes to the background. You will not think about it in most cases up to the moment when something happens. You will have no time, you will have no money, right? So just to think on those issues. And on the one hand, we will definitely say that it's worth trying to register things. It's worth trying to get the protection for your immaterial assets. On the other hand, well, if you can't, you don't necessarily need to obtain something in order to be protected. Sometimes there will be situation in which you need a patent, but you know, getting a patent is only a starting point. You need to fight for it. If there is an infringer that is equal to you, then you will probably make a good use of that patent. But what happens if something bigger happens? If somebody who's relatively bigger than you comes and infringes on you, right? And you will say something about this. You will not just agree to it. When you call Google, you have I can see 3 scenarios. In the first scenario, which is, I think, highly unlikely, they will simply pay you something for the situation, right? And for keeping it quiet. In the second scenario, if they will see that your patent is actually worth something, they will buy your company. In the third scenario, they will say that, okay, we might be infringing one of your patents, or the only one patent that you have. If it's in software industry, it doesn't necessarily need to be a strong patent, right? But we have a portfolio of hundreds of thousands of patents, so you are infringing hundreds of our patents, and go figure out. Try to do something with this. Try to invalidate those patents. Try to stand in procedures in 12 different jurisdictions and fight against Google, right? So maybe obtaining a patent is not the only right solution, right? Sometimes, even if you don't have any registered rights, but you're stubborn, you're patient, then it might happen that you're gonna win the battle that happens if somebody goes after your rights. So which brings us back to the story, which is actually the story of being determined to protect yourself. Well, we are working together with Bartek for several years now on different projects. We are separate companies, but we go together in many things. And it happens that we met a mutual client, which is MaxRoy.com from Poznań. They are, just to be honest, I'm running Raczyński Jóźwiak, but I'm also cooperating with Filipiak Babic, which is a dynamically growing law firm in Poznań, and they are providing the full ongoing legal support to Max Roy. And at the time when this case happened, the story happens, Bartek was working with patent attorney patent attorney firm in Poznań that managed Max Roy's trademark portfolio. So what happened is that Max Roy, among other activities, they also had a web store selling shoes. They called it Oryginalne Buty PL, which stands for branded shoes, and they were running it for like 2 years, up to the moment when we met. They were sued by a third company. The company actually claimed that the store uses their trademark. So there was a claim on infringement of trademark. That's the trademark under consideration. So the plaintiff said, you are using a very similar trademark to our, which is basically identical, right? And you're using it for the same business that we do, for selling shoes. You are infringing our trademark. And, you know, it's something normal. It's not extra. It's something which is not extraordinary to be sued these days. You know, it happens. It can happen. It doesn't necessarily mean that you actually infringe somebody's right, that you're guilty. It may happen that it's simply a way of fighting the competition. It is the below the belt action, but it, you know, we see it in the market. What was worse in this situation, it was that it doesn't start with lawsuit itself. It starts with preliminary injunction, and that's the court ruling that bans you temporarily some of your actions. In this case, court said that Max Roy should stop using the Oryginalne Buty notion in any form for the period of the proceedings, right? For branding, sales of products. So what they did, basically, district court told them, you can't use your domain, you can't use your logo anymore, but only for the time of when we will handle this issue, which is like 3-4 years. So you can imagine how they felt about it. What's worse with preliminary injunction is that when you attacked in that way, you receive the court ruling without having the opportunity to say something. You can, the only thing you can do, you can appeal, but still the preliminary injunction is in force. It can be enforceable. It is enforceable all the time. So, and it is based only on what the plaintiff said. And what they said, well, what they say, typically, they don't have to prove that they are right. That's what's done in the proceedings after the lawsuit. Right now, at this point, they had to make it probable to the court that the infringement happens. So they provided court with certificate of registration of a trademark and printouts from the web store, from the website, just showing that there is Oryginalne Buty PL in the same graphical form as the registered trademark. And court said, okay, it's probable, so I ban the use of Oryginalne Buty for the time of proceedings, right? It happens a lot in our field. You could assume that since this is such an effective way of protecting somebody's IP, that it will cost a lot, right? Typically, if you go with a lawsuit, you will have to pay at least 5% of the total amount that you claim as a course fee, plus the attorney's fee, right? Plus our remuneration. Well, actually, in case of preliminary injunction, it's relatively cheap. It costs 100 zloty. That's all. 100 zloty certificate of having a trademark and some printouts. And you're already done. You're probably obtaining a preliminary injunction. Well, Maxroy, they were shocked. You can imagine a young team of people that are passionate about what they do. They are idealistic. They believe in society and justice. And now something like that happens. And it happens not only that another company attacked them. It's the court that made the ban, right? So it was an attack of the system. And sorry, I saw that references to Star Wars are quite popular these days. We are all waiting for the new trilogy. So it will happen again, referring to Star Wars. So the system was attacking them, right? They were asking those questions, why it happens, why, and why. You could ask why they were so shocked about this. I mean, you can see those marks are, they are identical. One could say that they had it coming. Well, the problem was that this trademark, which was registered, it was filed for registration on 6th of April, 2010. And Maxroy was using his brand publicly since January 2010, so for 4 months prior to application. Well, I had to actually I had to answer the question of Maxroy's CEO, how is it possible that somebody is suing us over the infringement of a trademark that they stolen from us, right? That's the case here. So Bartek, just give us the details.
As you see, we deal here with a trademark infringement, but this scenario is also possible in relation to any other intellectual property rights. It may look the same in relation to patents, utility models, designs. It is just a common scenario. But we need to make sure that we will all go the same path, that you'll understand our way of thinking. So we need to define the trademark. We need I need to tell you what a trademark is. Sorry about that. So a trademark is a sign capable of distinguishing goods and services. It does not necessarily need to be a logotype. It may be a word. A simple fanciful word registered in any form is still a valid trademark. We deal with shape trademarks. We deal with number trademarks. We deal with sound trademarks, and even some colors are registered as them. So can Oryginalne Buty, brandedshoes.com, be a trademark? Is this a sign capable of distinguishing good of one entity from goods of others? One may say, hey, come on. This is the common phrase. You may find it in a dictionary. So, okay, how about Apple? You may find it in a dictionary as well. Can you register it? Is it generic? In fact, it isn't generic. It isn't descriptive in relation to computer hardware and software. It is generic for apples, though. So, okay, how about Oryginalne Buty? How about branded shoes for branded shoes, right? Is it descriptive? Is it a trademark? Right now, we have to assume that it is, because as it was presented a couple of minutes earlier, the Polish Patent Office granted the exclusive right for this trademark. Okay, a scope of protection of its trademark. How we deal with it. Maybe we can catch something, because, of course, we took this case and we had to defend the guys. Scope of protection. The intellectual property rights, patents, trademarks, designs are not absolute. There are limits. First of all, the territoriality principle. We get a patent in Poland, we are protected in Poland. There is no a worldwide patent. The same with trademark. Of course, those guys got the registration in Polish Patent Office, and we were using the mark in Poland, so this is not the case. Then time. Most of the rights do lapse. They are valid only for a period of time. They're not perpetual. For patent, it's 20 years, for design 25. How about trademark? those are perpetual. You may renew your trademark every 10 years until as long as you wish. Okay? So this is not the case here. Subject matter. As it was told earlier, the marks is protected only for goods and only for services which are included in the registration certificate. Unfortunately, those guys registered it for almost identical service as ours. So sale of shoes, it's quite obvious as they're doing a hostile takeover of our intellectual property. Okay, what then? Maybe there are some special exceptions. Come on, it's not fair that the guys are taking our trademark that we are using for years. Okay, we've got the prior user exception. Hooray. So the law tells us that if you were using your mark locally and somebody registered it as a trademark later, you may continue using it. Okay, but you have to use it locally. And we are selling shoes online. Remember, the same scenario will be in relation to patents, in other rights, not just some banal things as a trademark. So, okay, we are not using it locally. Maybe something else. Okay, descriptive use exception. You may always use descriptive words in order to describe them. Forget about the registration of Apple. Well, help? Okay, forget about the registration of Apple trademark. They will not be able to prevent you from using the word Apple in relation to resale of apples, right? So this principle, can this principle be applied here? In fact, it can't, because we are using not only the word Apple, branded shoes, but we are using also the graphical layer of that sort. Yeah, we copied, or they copied, those marks under study were just similar also on a graphical layer. So what can we do? Okay, there's one solution, invalidation. Like, make the trademark go away, invalidate it. It is quite common that the examiners of patent offices do make mistakes. I mean, sometimes this is the wrong assessment of law, but in most cases, the examiner just don't know the whole situation, do not know all the facts that are relevant in the situation, and this is our job to present them, those facts. The invalidation grounds are different in relation to many rights. Like, take patent, for example. The patent, in order to be protected, must be new. When patent is not new, it will be invalidated. What does it mean to be new? It must not be disclosed before the application date. So this is important if you want to protect your technology with a patent. If you disclosed it more than 6 months before the application, that's it. Your invention is not new, you can do nothing about it. And the fact that it was you who disclosed it is of no importance. How about trademarks? In trademark law, we do not care about novelty. You may use your trademark for years and just then apply for protection. What's the most important factor for invalidation of a trademark is a similarity to other earlier rights. But we do not have any earlier rights, I mean trademarks, right? Our client forgot or did not register anything. Let's look deeper. What are the other common grounds for invalidation of a trademark? Let's question it being a trademark at all. It may not be capable of distinguishing good and service. Come on, those words are generic. We may invalidate a generic word for those goods and services, right? Okay, this was our argument, but it was not a winning argument. There were two main issues, there were two main winning arguments in this case. First, the argument of bad faith application, and the second, the most important one, copyright infringement. Bad faith application, legal definition, sorry about it, conduct which departs from accepted principles of ethical behavior or honest commercial and business practices. So what do we have here? We have accepted principles, we have ethics and honesty. As you're probably thinking right now, it is really hard to define it, to catch this, and to prove this. But sometimes it's successful. Okay, and the big argument, copyright.
Yes, copyright. Actually, if I may hit this. We are saying two things here. That our coworker, our meaning my client, our client, Maxroy's coworker, created the logo itself. And we said the second thing, that the author's material rights, let's call them copyright, that they were transferred to Maxroy. That Maxroy was now the right holder of the copyright. And having a copyright, which is a copyrighted material which is used in somebody's trademark, is a ground for invalidation of that trademark, because that trademark infringes our copyright. The problematic issue here was that we had to prove it, because the counterparty was saying exactly the same thing, that they were the ones who created the copyrighted material, the logo. We said that it came up in January. They said it came up in December, right? So we got the co-worker to court and to patent office. He was questioned. He had to testify. He testified that he created the logo in Photoshop. He used impact font on it. That he used a background, black background, white letters. One of them was orange. Some of the letters were capitalized, right? And he told us the story about this. He told to the court and to the patent office the same story, which is not very complicated. I mean, how long can you say something about creation of such logo? He also said about creation of the entire website design. He was doing that as well. But then CEO of the plaintiff comes in and starts to testify, and he says that he created the logo. He used Microsoft Word for it. He used black background. He used white letters. One of the letters was orange, and the rest, some of the letters were capitalized. Well, he said more. Well, I actually used Keynote to create the logo right now, so you can do it in Microsoft Word as well. He also said that he used Verdana font, right? So, which is not exactly the same as the one that is registered. After all that interrogation, well, judge had to decide, patent office had to decide, and basing on that, well, they also say, the plaintiff also say that this is so small, the logo, this is so simple to do, that it actually doesn't have the copyright protection, you know? And, well, they actually could have won this argument in Germany, because in Germany, you have a kleine Münze theory. It's little coins theory, which says that those creations of human that are simple, little, doesn't necessarily go under copyright protection. So you have to do something more. You have to be artistic in some way, right, to get copyright protection in Germany. Fortunately, it's not the case in Poland. In Poland, everything that is created by human, that bears this certain, that is distinguishable from other creations of human, they will be protected in general. So just a side note with reference to that photo. Do you know how hard today is to find a picture with a Polish flag without any political references, without Kaczynski on it? It's crazy hard when you're trying to do that on Creative Commons license. We were actually, I was finishing this presentation in the train coming here, and we happened to sit close to Tatiana, who's that's the lady on the picture, and she said, "Well, I have a good picture for you. I have an almost Polish flag because it's from Indonesia, and the picture was taken in Indonesia." So she granted us a license to use it. So thank you very much. Dziękujemy. Yeah, we used it. It sounds fair to use it. It's a nice picture. So, so coming back to copyright, we can assume that even those little little points, little creations will be protected. What's more, there's no requirement of registration like with trademarks or with patents. In USA, there was a time when you needed to register your work of art in order to obtain copyright protection. There is a separate copyright office in US. They're still there. You had to give one of the copies of your work of art to Library of Congress, and your work of art was registered then. You had a protection. There's no such thing in Poland. From the moment you made it, you fixed it, from the moment it came out from you, in a way, it's protected. It also doesn't have to be finished. You know, if you're making a draft, it's already protected. So you can start designing something, it's protected. One important thing that I wanted to point out here is that author of the logo was not our client's employee. There is a significant difference between employee and co-worker when it comes to copyright and the assignment of copyright. Employee will be somebody who's employed on the basis of employment contract. That is labor law. Co-workers will be all those freelancers or even the ones that sit from 8 to 5 on their desk but doesn't have employment contract, that work on a cooperation contract of some sort. With reference to that first group, the employees, typically if the work of art is created within the employment, the copyright will pass to employer more or less automatically, right? While with co-workers, you just need to have a separate agreement transferring those rights. Because if you don't, if you simply say, hey, could you just write down some things for me, or could you just design something for me? Okay, he will do his job, but you will not get, by that simple thing, or an email saying that, okay, do it for me, you will not acquire copyright. You will simply at least acquire license to use it, right? And if you want to say that you have, you're a right holder, you need to have a contract which is written, I mean pen and paper, signed, or if you want to do it in an electronic form, which is quite, I would say, complicated in Poland. You can do it, but you have to use this certified digital signature, right? So 2 versions of contract possible. Written on paper and signed, or signed by digital signature, with only that certified one. Yeah. Okay.
To make the long story short, both the patent office and the court believed that it was our guy who created the logo. It took us 3 years to prove that. So 100% victory? No. Think about the thing that began the whole story. The interim injunction, the temporary ban not to use the trademark during the course of proceedings.
Right. So the preliminary injunction was still in force throughout the whole story. You have that was this pending preliminary injunction, because we actually appealed, but the court says, the court of second instance said that, okay, I've seen the certificate of registration of a trademark. I've seen the printouts. It seems that it is probable that there is an infringement going on. So, so the preliminary injunction stands, right? So we had it all the time with us. Max Roy should stop using those 2 words, oryginalne buty. I mean, if you don't, it's against the law, right? You become an outlaw if you decide not to do it. If you decide on purpose, you just go, you know, to the dark side of this whole business. And it can, apart from being contrary to the law, it simply can finish with a fine being imposed by the court. At the time of the proceedings, that fine started from 1,000 zloty and could end up on the level of 100,000 zloty. In the end of the proceedings, law changed, and the new law said that if you will not obey the preliminary injunction ban, you can pay starting from a fine starting from 10,000 zloty up to 1 million. So you just simply need to be quite bold to make a decision on not obeying the preliminary injunction, right? Well, fortunately for Maxroy, they are quite bold in what they do. They decided not to obey throughout the whole 3 years history of that proceedings. They were not obeying the court ruling. Yeah. Still, they had no. They were not certain if the brand will survive through that proceedings. After 3 years, well, we were seeking judgment. It could go wrong, right? So they were not sure if they will win this case. They were not investing in growing that business as much as they could. To be honest, it was the only way for that brand to survive, right? Because if they didn't, they should or rebrand and just start from scratch, or 2 years of marketing effort would go in vain, or they could do what they did. Yesterday I was talking about this with Maxroy's CEO, and he told me that despite winning of it, we can see some lost chances along the way. They see that they could grow the business bigger. They were, as they were not sure if it survives, they were not doing that. Okay, so, because there could be things that could go wrong along the way. I mean, apart from lawyers' mistakes, which do happen, but those two important issues that could happen. One of them, the plaintiff could file for imposing a fine on us, right? It happens on motion of the other party, so they could do it at any step of the proceedings, and we would have to start paying the fines for not obeying, right? So it was a ticking bomb, actually. The other thing is that our proofs for having the copyright, right, for being right holders, could not be as efficient as they were. We could have problems with, because normally, look at your practices. Do you have agreements with all people that you work with? Are you sure if you have enforceable copyright transfers in them? Do you have those provisions that will say that on which fields of exploitation copyright is being transferred to you? It happens, especially in case of young entrepreneurs, that you don't have that, or you could have simply the author could go to the court and could not be as reliable as he was, in fact. In those cases, we would probably lose, or at least our chances would go down.
Okay, lessons learned. Lesson number 1, people are assholes. I mean, you came here not to learn how to do the hostile takeover, rather how to defend from it. But there are some guys like this one who would like to make use of you. Fortunately, nobody sues startups, as Professor Mark Lemley of Stanford School of Law says. But he doesn't mean that you will not be sued at all. He just means that you may be sued when you'll get bigger. First to file is first to get the law. Those guys were first at the Polish Patent Office, thus they got a registration. This is lesson number 2. Lesson number 3. Fortunately, granted rights may be invalidated. So the decision of Patent Office is not the end of the world. But look at our story. Our client was very lucky. he was very lucky he could do this stuff, right? There were no fines, the copyright agreements were okay. We may have as well lose this case. Lesson number 4, copyright can be strong. In Poland, we do not register copyrights, and we tend to neglect them, underestimate them. We think that a patent, a certificate issued by the patent office is a strong right with copyright. It's hard to get, it's easy to get, hard to execute. It's not, that's not the point. Copyright is a very strong law if we have a proof of it. If we're careful enough to care about the paperwork, to do those written agreements with the authors. And lesson number 5, IP rights cost. You may decide to prosecute your right at the very beginning, file your application in the patent office. This will cost you. Sometimes you decide just to go with the flow, forget about it. Very often this is a very good strategy. But then there may be some costs later in litigation. Whatever road you choose, you will never remain unprotected. There will always be some tools that will protect you. It would be great if this was earlier registered trademark of our client, but still without it, they had the tools of copyright and fair competition and so on and so forth.
Yeah. So I guess our message here is, like I said, not to frighten you, because the certain point is that you will not avoid risks along the way, right? Once you develop, you will not avoid the risk of, being infringed or infringe somebody else. So if that's the point, you might as well simply focus and get your job done, and think about IP and protection, and think about how to about those risks, but just not think about it only about those things. We are the ones who think only about protection of those things. You should just get your job done. So I guess we will stop here, and thank you for your attention.